Welcome to the Docketing Excellence webinar series.
Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective US-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Woessner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 10th in the series. Today's topic is the right way to calculate due dates in EP and China. We have allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit questions at any time. The question will be held in the queue until the end of the presentation. The presenters today are myself and Dr. John Collins. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. John, can you please introduce yourself?
Thank you, Anne. Yes, John Collins. I am a European patent and a trademark attorney and a UK patent and trademark attorney. I have over 25 years experience of practice before the UK and EPO. I was previously a senior partner at a large UK law firm before joining Schwegman in an of-counsel role, where I've now been for several years, just over 3 years. I would like to talk today a little bit on the calculation of EPO due dates, and Anne will be talking about China.
So yeah, John, if our audience is docketing in China and the EP, you may notice that due dates calculated in your docketing system don't match the due dates given by your foreign associate. This program will explain why and also explain the proper way to calculate due dates in these countries. So today's topics will be first, calculating due dates for EP, which John will cover, and then second, calculating due dates for China, which I will cover.
Okay, thank you, Anne. Let me talk about the calculation due dates in the EPO. There are 3 areas I want to talk about today, and culminating in the 10-day rule, but starting through the 2 sets of communications. First set of communications, which come under Rule 161 in brackets 2, and Rule 162, and the communications that come under Rule 69 and 70. All of these communications are part of the EPO practice that occurs before the examination process, and are, in my opinion, one of the most confusing areas for foreign practitioners. So I want to try and take you through those, understand them a little bit, because they are the communications which cause the most confusion when it comes to what is the due date and how to apply it correctly. So let me move on then to Rule 161 and 162. There are several forms that are relevant for these rules in the EPO, and the EPO conveniently use form numbers for each of their forms. They are standard forms, and therefore throughout this presentation I'll be referring to the form numbers. And this Rule 161, 162 is a rule that is applied to communications which are post the regional phase in the European Patent Office following PCT application. Rule 161-162 communication on a form 1226BB is issued if there's been a negative opinion by the EPO in the International Search Report. So where the EPO is the International Search Authority, they will issue a search report and an opinion. When you enter the regional phase in the EPO, you will then get this form, assuming that amendments and comments have been filed on entry into the regional phase. And in response to this form, you have the option. Apologies, I seem to have jumped forward 2 slides. Let me just step back 1.5. This is 126AA. Step back 1. This form is issued if there's been a negative opinion by the EPO in the International Search Report and no amendments or comments have been filed in response to that. And since you've not responded to the EPO opinion, there is a mandatory 6-month deadline to respond to the opinion. When I move on to the form 1226B, when there has been a negative opinion, but you will have already filed a response, you may have filed an opinion response upon entry into the regional phase, being diligent to preempt the need to respond, in which case you get a further opportunity to file voluntary amendments, and the application is not deemed withdrawn if you don't respond because you've already done so. And you'll see the difference in wording between the form 1226AA and 1226BB by the wording "you may comment," which is significantly less onerous. There is also a form 1226CC, which is issued in other cases. So this is quite common for US-based PCT applications where the USPTO is the ISA. In this case, there has been there is no need to respond to an opinion. There isn't one if the EPO was not the ISA, and therefore there's a voluntary option to file response within 6 months, file voluntary amendments. And there is also a possibility that the EPO was the ISA and they gave a very positive opinion, in which case there are no objections. So in this case, the purpose of the communication is to give you an opportunity to file voluntary amendments under using this form 1226CC. So the three ways here of 3 types of communications. The communications have 2 independent deadlines, which is important for docketing. We realize that there are 2 rules being applied in one communication. They both have the same deadlines, but they are nevertheless 2 different rules. Rule 161, in brackets 2, requires a response. Rule 162, which accompanies, is included within that communication, is the rule regarding claims fees. The EPO applications incur claims fees for each claim above 15. If you file an application with more than 15 claims and don't pay the claims fees, the appropriate box will be ticked, pointing out that you haven't paid these claims fees under Rule 162, and you must do so. Either you pay the claims fees or you amend voluntarily or in response to the opinion to get the claims below 15. The important thing, which I put in bold here, is that the deadline applied under Rule 161, 162 communications, all these 3 communications set a date which is from the date of notification. The 10-day rule applies, and I'll explain more later on as to how to correctly apply the 10-day rule to the calculation of the deadline. Just take a look at what a form looks like. This is the form 1226CC, and you see there's 2 parts. It does help you. The EPO are very helpful here. There's clearly 2 parts, so numbered 1 and 2, which need to be read and considered. The first one, 161.2, in brackets 2, that is. In this case, because it is the 126CC, it says you may amend your application. And at the end of that passage, that section 1, there's no nasty statement that your application will be abandoned if you don't do this. So this is an indication that it is a voluntary amendment. The second part under 162, they have 3 boxes, and either you've paid all of the necessary fees, or there are less than 15 or less claims in the first box. Alternatively, you may have an automatic debit order. The associate may automatically pay for any claims, fees, which I would suggest is not a good practice, since you should try to avoid them generally, and it can be expensive. And the last one, quite commonly for EP application, this is typical. An EP US application is typically of around 20 claims, and therefore you'll be notified that those claims have not been paid for. And you've now got the option to either pay for them or voluntarily amend using the 161 in brackets 2. So these fit nicely together, but you must understand that there are 2 deadlines when docketing. And if you docket them as one, you have to take some care, because if you miss these deadlines, potentially, the point about having 2 deadlines is that if you do miss these, you can, of course, use the EPO's very favorable fallback position of further processing. The problem is that you will have 2 deadlines to further process, which incurs 2 further processing fees. This is a common mistake, should we say, by practitioners when they don't realize that you have to pay further processing fee for each deadline. So let's take a look now at Rule 69 and Rule 70 communications. These are issued, the forms 1081, 1082, and 1083 are issued for EP applications. These are direct national applications, or direct regional applications strictly for EPO, but so we're not talking about the PCT here. So this would be typically a convention, Paris Convention filing, for example. So as I said before, you won't get a form, the previous 161, 162 communication. Those are for PCTs. Instead, you will get these forms after the search report has issued. So form 1081 is a combined report of the publication date of the search report, which sets the examination fee deadline and the deadline for paying the designation fees and responding to the opinion. So in this case, under form 1081, the examination fee and the designation fees are due, and an opinion must be responded to, the opinion of the search authority, the search examiner. A form 1082 is a form when the exam fee was paid earlier. Form 1081 is typically for normal Paris Convention application. You don't pay the exam fee on filing normally, you can pay that later. For Form 1082, when you've paid the exam fee earlier, this may be because you want to accelerate examination, accelerate the prosecution of the application. And the form invites the applicant to confirm the application to continue. The purpose for this is the examiner's given you an opinion, which may be very negative, and the applicant may look at it and go, oh no, let's give up. The purpose here is to allow the applicant a chance to withdraw and obtain the feedback. So you need to confirm that you do want to go ahead. And there's also a reminder always included that you might not have paid the fee for the designation of the designated dates. And you do need to respond to the search opinion again. This is a typical form you'll get for a divisional application, because you normally have to pay all of the fees on filing a divisional application, and therefore the exam fee is being paid before you've seen the search report. Now, Form 1083 is much less common. This is for the case where you have filed the application with an examination fee paid, and you've already responded to the search opinion. Maybe as soon as you've got the search report, you're right on the ball and filed the response, in which case, when they send this form, it will be simply informing the applicant of the publication date and a standard reminder that in case you haven't paid the designation fee, you need to do so. In which case, there is no date docket, because all of it is everything's been done. But a 1083 is very rare. So the important thing to remember about Forms 1081 and 1082 is that, again, there are 2 independent deadlines that must be complied with. 1083 has a single deadline, potentially, of a designation fee that you need to check. If the designation fee has been paid, then of course there's no need for a deadline. But if you haven't paid the designation fee, then you need to do so, need to docket the deadline and make sure that's done. The important difference over the previous discussions on Rule 161, 162 communications is that the deadline is calculated from the date of the publication. Now, this is the publication of the search report. The EPO calculates everything from the date of the publication of the search report. Let's take a look at what one of these forms looks like. This is the form 1081. It is set out in two parts, but it is slightly less clear than for the form Rule 161, 162 communications. The first part deals with the publication notification, or with three parts. The first part is informing you of the date of publication, in this case, 4th of November. And then the second part draws your attention to the need to comply with Rule 70. And I've highlighted the area there which says, within 6 months of the above mentioned publication date, you must. And it sets out what you must do. The designation fees must be paid, the examination fee must be paid. Now, generally fees docketed together. These do come together. So it's a question of whether you strictly should docket 3 dates, but you can indeed docket designation and exam fee together. But certainly there is a fee date, and there is a need to respond to the search report opinion as a second date. And the latter part of the letter simply gives you information regarding the level of fees, and note in bold near the bottom, it gives you the warning. The application will be deemed withdrawn if you don't do these things. So it's a very clear warning if you look at the text in these communications. Moving on to Form 1082. This is the communication which again tells you about the publication date. In this case, it points out that you've already requested examination, paid the fee, and it says, so this says you need to indicate that you need to indicate whether you desire to proceed further with the application. And once again, as highlighted, the deadline is within 6 months of the above mentioned publication date. So that's an important difference to look at, is that what it's telling you, the deadline, what sets the deadline is indicated in the communication. So another form with regard to Rule 70 to consider is what happens on a different route when you have gone through the PCT route. The form issued once you have gone through the PCT route, you will get the Rule 161 and Rule 162 communications. You'll then get a search report, and you'll then get this form instead of the previous forms. This Form 1224 sets a mandatory deadline again, because of course you're a PCT application now, you have already paid the fee on entry into the regional phase. So this has some similarities to the Form 1082, because you paid the exam fee, so you've got to confirm that you still want to go ahead, because you've received a supplementary European search report, and you've got to now comment on it. The communication, importantly here, has two deadlines. Again, the Rule 70 deadline and Rule 70A deadline. So confirm that you're going to go ahead, and comment on the objections by the examiner. The important difference over the Form 1082, however, is that the deadline is set and to be calculated from the date of notification. So this communication is different in that the deadline is calculated according to the 10-day rule. So let's take a look at a Form 1224. This is what it looks like. It has the first sentence stating a supplementary search has been drawn up and published under publication number blah, blah, blah. Now, since you've already paid the exam fee, you've now got to confirm that you wish to go ahead. And that is within 6 months of notification of this communication. And if you don't do so, again in bold in the letter, it will be deemed withdrawn. That's the first point. And the second point, again, it's unfortunately this letter doesn't highlight them as point 1 and point 2, but the next sentence says you are invited within the above mentioned period to comment on the objections. And if you don't, again, another warning at the bottom, if you don't do so, the application will be deemed withdrawn. So we have a clear set of two deadlines there, with a difference of approach in that the calculation is carried out from using the 10-day rule. So that leads me nicely now into a discussion of the application of the 10-day rule. So we've talked about in the previous communications, on those communications, that we have calculation from a publication date and calculation from a notification date, and therefore the 10-day rule applies. The only way to identify that is to read the communication or just to learn which applies to which forms. So let's talk about the 10-day rule. Here is an example form, and again, it's the Rule 1224 form. And this time I've included the header, which includes a date. Now, the date that is included in the form is the date of the communication, the date that the EPO stamps and sends the communication out. Now, these days, with electronic communications, mainly most EP attorneys will receive it on the same day, or within a day or so, because there are a few attorneys now who receive mail. But that indicates the date that the communication was sent. So that is the communication date. And this is a Rule 1224. And this sets a 6-month deadline from the date of notification of this communication. So I'd love to sit here in front of a room full of people and see, putting up hands, how you calculate this date. Do you sort of put 6 months on that and then think, well, I've got an extra 10-day grace period? If you do so, you've just potentially allowed your attorney, if you allowed your attorney to work to that deadline, potentially lost the application. The 10-day rule does not work that way. There is no such thing as a 10-day grace period. And one of the important things I wanted to deal with today is to slay the dragon, to kill the myth that there is such a thing as a 10-day grace period in the EPO. The deadline is calculated from the date of notification. Now, importantly, I've used two different words there. There's a date of notification and a date of communication. The date of notification is deemed to be 10 days after the date of communication. The purpose for this was that allowing postal delays, the EPO used to allow you to prove when you received a communication because that was the date in which the deadline started. The EPO liked to ensure that the applicant had the full set term to consider the response, not reduced by any postal delays. But this got very complicated with people proving dates. So the EPO brought in, some years ago now, this additional 10 days to ensure that within 10 days, everyone should have received their communications. That's plenty of time. There'll be no communication delay. So it's still possible, by the way, if you don't receive it within 10 days, to go back and prove, if you can prove you didn't receive it, to reset the notification deadline. But most of the time, 99.9% of the time, the date that you are deemed notified is 10 days after the date of the communication. So in order to calculate the deadline, what is most important is that you add 10 days to the date of the communication to determine the date that you were notified, i.e. the notification date, and then calculate from there the period that's been set by the EPO. So let's take a look how that works. Again, pulling up the form, we've got a date of 20th of August, and we have the notification date indicated in the form, so within 6 months of the notification of this communication. So what I've done here in the next slide is pull up how it is incorrectly calculated. And this is a way of failing your EPO exams, for example, if you wish to become a European attorney. If you've got a communication dated 20th of August, as we have there, and the deadline is set at 6 months, you say, well, deadline must be 20th of February then. You then use a 10-day grace period, which takes you on to the 2nd of March, since February is a 28-day month, normally, of course, not in a leap year. If you calculate this correctly, you would instead note that the communication is dated 20th of August. You would add 10 days to that deadline to make the date of notification, to determine the date of notification of 30th of August. And you would then calculate 6 months from that. And according to the rules of the EPO, 6-month deadline is a calendar month deadline. And unfortunately, February doesn't have 30 days, so it is the 28th of February. Note the difference. If you had incorrectly calculated the date, you would be allowing your attorneys to file a response on the 2nd of March. And indeed, the deadline had already passed because it was, in fact, the 28th of February. And this is the extreme case. And in some cases, it works in your favor. But it's not a gamble I think you should take. Most importantly, what I've only been discussing today is the pre-examination deadline communications. Of course, the 10-day rule is something that also applies to a further processing notification. If you had missed your deadline, the EPO will send you a communication setting you a 2-month deadline from the date of notification to respond. And if that communication was dated the 20th of August, and again, due to the pressures of work, we all know what it's like, the attorneys work right up to the deadline. If you told the attorney, or indeed the attorney assumed, that they had this 10-day grace period and filed a response on the 2nd of March, they would have missed the further processing deadline. And now you're into restoration. And if you wish to put a case to the EPO, that this is how you calculate your deadlines and you have a good docketing procedure, and therefore please could you restore the application, they will laugh at you and you're dead. So do not use this procedure. Particularly further processing is deadly. So what I wanted to get over today is the myth, dispel this myth of a 10-day grace period. The use of a grace period requires the docketing of an incorrect deadline and reliance on some sort of last-minute calculation by people. Everybody gets confused. Has this 10 days? Has it not? Well, actually, in the example I just gave, in fact, these mythical extra days would in fact only be 8 days. So there is no such thing. It's an incorrect use of the calculation. It's an unsafe practice, and indeed, I would say that potentially your malpractice insurer would not be happy to know that you are operating in this way. So, summary. The important thing is to read the EPO communications. Look at the form number, read the communication, look at what sets the deadline. Is it from the publication date or is it from the notification date? And remember that there is more than one deadline in all of those communications. You need to docket each deadline independently. It is possible, for example, where you have response to the Rule 70 communication, say, well, the client's not made his mind up yet about how to respond to the objections, but so, you know, I may need to go into further processing for that because I don't want to file some made up response. Well, make sure you at least respond to the Rule 70 Rule 70 deadline, which is confirming you want the examination to proceed. And then you only have to pay one further processing fee for the Rule 70A deadline when you further process and file the response. So there are 2 deadlines. And then most importantly, apply the 10-day rule to calculate the deadlines correctly. Yes, I know there are many European attorneys, EP service providers, who do not use the 10-day grace period, the 10-day rule, or apologies, and use the 10-day grace period in some form because they like to have some date in advance. I think the point here is that you should require your service providers to inform you of the correct deadline. The deadline is a deadline. If you want to rely on reminders or some other means of making sure the work is done, that is an internal service issue and not a method of efficiently and properly docketing deadlines. Never use the 10-day grace period. It is a myth. And on that, I will hand over to Anne.
Thank you, John. I am going to talk about how to calculate the time limits in China. I'm also going to talk about what we call the 16-day rule in China. Some might call it the 15-day rule. And then walk through some examples. 1 second here. Getting my control on my slides. So, okay, there's my summary. Calculation of time limits in China, then the 16-day rule, and then walk through some examples. So, first of all, the calculation of deadlines in China is similar to calculation of deadlines in the EPO, except that instead of a 10-day rule, there's a 16-day rule. Most deadlines in China are calculated from the date on which a notification is presumably received. For example, the time limit for the applicant to go through the formalities of registration, as provided in Rule 54.1, is calculated from the date on which the notification of grant patent rights is presumably received by the applicant. The date on which the document is presumably received refers to the 16th day from the date of issuance of the document by the Patent Office. This is similar to the EPO calculation, except you allow 16 days from the date of the document rather than 10 days. You may think of this as the 16-day rule in China. Some may call it the 15-day rule in China because of the way it's calculated. When a document is sent by the Patent Office by mail, the 16th day from the date of mailing shall be presumed to be the date on which the document is received. And it's very important to note here that the first day of any time limit is not counted in this calculation. This is a subtle difference from the EPO's 10-day rule. The easy way to do this is to think of the mailing day as the first day of the 16-day period. So, for example, if the notification is issued by the Patent Office on July 4, 2017, the date on which the notification is presumably received is July 19, 2017. To calculate this, you count July 4th as the first day, and then you add 15 days. So if you could see me, I'm counting on my fingers the 15 days. July 5th, 6th, 7th, 8th, 9th, 10th, 11th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th. July 19th is the date of the applicant is presumably notified. So if an office action with a 2-month period for responding is mailed by the Patent Office on June 6, 2017, the date on which it is presumably received is June 21st, 2017. So again, to explain this calculation, remember the first day of the time limit is not counted. So in this case, the office action is mailed by the Patent Office on June 6th. That day is the first day of the 16-day period. Then you count 15 days from June 6th. That's June 21st, which is the date the office action is presumably received according to the 16-day rule. Now, for a response with a 2-month deadline, the 2-month period is calculated from the date on which the office action is presumably received. In this case, the office action is presumably received on June 21st, so the response is due on August 21st, 2017. That is the date that you should docket in as the actual deadline for responding to that office action. So let's look at another example. In this case, if a notification was mailed by the Patent Office on December 16th, 2016, the date on which it is presumably received is December 31st, 2016. Again, remember the first day of the time limit is not counted in the calculation. So in this case, the notification is mailed December 16th. That day is the first day of the 16-day period. Then you count 15 days from December 16th. That's December 31st, which is the date the office action is presumably received according to the 16-day rule. So for a notification with a 2-month deadline, the 2-month period is calculated from the date of the office action was presumably received. In this case, that was December 31st. So the response is due February 28th. I'll let you think about that for a second. In this example, since there is no 31st day in the month in which the response is due, the time limit to respond expires on the last day of the month, which is February 28th. So if you had treated the 16-day rule as a grace period and added the 16 days at the end of the 2-month period for responding in this example, you would have missed the deadline. Instead, that 16 days goes at the front end of the calculation, and then you add the 2 months. If you had treated it as a grace period, as many people think of it, you would have taken the December 16th mailing date, added 2 months, which would take you to February 16th, and then added the 16 days, which would have March 3rd as the deadline. That is wrong, and that deadline is after the actual deadline of February 28th. So again, similar to John's example, here's an example where in China, you would have missed the deadline by viewing this as a grace period, which is not the correct way to calculate this type of deadline. So in summary, the 16-day rule in China is not a grace period. You apply the 16-day rule correctly to calculate the day the document was presumably received, and then you docket the due date off of that deadline. So in summary, today we've discussed the right way to calculate due dates in the EPO and China. More specifically, we explained the 10-day rule in the EPO and the 16-day rule in China. If you have any questions about Black Hills IP services and processes, please contact our Vice President of Sales, Jim Brophy. His contact information is on this slide. In this recording, we're not taking live questions because this is a re-recording of a previous webinar. We'll post the slides and an audio recording on our website, which is www.blackhillsip.com, under the Webinars tab. I'd also like to take a minute to announce the Docketing Excellence group on LinkedIn. We've recently created a group for docketing professionals to connect and communicate with other professionals, to share ideas, ask questions, bounce ideas around, and to continue to discuss some of the topics and issues that we're talking about in this webinar series. We'd love to have the audience join our group on LinkedIn. It's very simple to do. All you need to do if you're a LinkedIn member is go to the website docketingexcellence.com. That will redirect you to the page where you can sign up for the group in LinkedIn, and then you're connected with a group of other docketing professionals. We're very excited about this group and looking forward to getting some active discussions going through this group. So thank you for participating today. We hope you will join us for other webinars in the future in the Docketing Excellence webinar series. Thank you.